All right. All right. So, hello. Thanks for being here. I want to talk about motions to reopen. All right. I'll be doing this manually. Who knows what a motion to reopen even is? Yeah?
It's to reopen some sort of proceeding.
Yeah, good, perfect. So let me just say it like this. Motions to reopen are serious and kind of scary and kind of risky, and they come at a time where nobody wants to be there, right? Motions to reopen means typically that you've lost your case. You may have lost your appeal. You may have been ordered deported and you didn't even know about it, right? You may have been ordered deported and you fought your whole hardest and the judge still denied your case. You might be eligible to appeal your case, but maybe not. But let's just be real. The people that are calling our office saying, I need a motion to reopen, they're like typically panicking, all right? It is not a happy place to be pretty much ever, all right? So who needs one? Somebody who has lost in court and somebody that already has a deport order that is like signed and they're like waiting around to see if ICE is gonna come pick them up or not. Sometimes a motion to reopen is the only shot they got. Sometimes not, right? But that's the context. That's kind of why this matters. All right. So let's talk about the basics. Any motion to reopen has to state new facts, right? The idea is that something has happened that wasn't presented in the court. Otherwise, why would they need to reopen it? So you've got to show some kind of new facts that were unavailable and couldn't be presented at the initial hearing. The motion has to be supported by affidavits and evidence. There are time limits and number limits that we've got to be really, really cautious of, all right? Motions to reopen typically have to be filed within 90 days of the removal order. There are exceptions that we'll talk about. And typically, a person only has one shot. Typically, everybody only has one motion to reopen, and that's it, all right? And they have to comply with the practice manual, either the BIA practice manual if it's to the board, or the immigration court practice manual if it's to the immigration court. All right. There are 7 types. This is not published anywhere. This is the way I think about them. All right. There are 7 types of motions to reopen. These are not listed like this in the Immigration Nationality Act. The Act itself is a mess on motions to reopen because some of them are listed in code sections all over the place. All right? There's one based on the general authority, which we'll talk about. There's one based on in absentia orders. What does that mean? What does that mean? You didn't show up in court. Ingrid, good job. All right? One based on ineffective assistance of counsel. What does that mean? Prior attorney messed up. All right? One based on changed country conditions that allows you to apply not based on what's happened to you, but what's happened in your country, all right? And showing that you're eligible now for asylum, withholding Convention Against Torture relief. One based on VAWA, one that's a joint motion, which I'll talk about, and one based on what we call the sua sponte powers of the BIA or even the immigration court, and they can basically, of their own accord, reopen a case. All right, so these are the 7 types. And in the next 5 minutes or so, we'll go through and we'll discuss each one of these. Okay? So, general authority, motions to reopen. All right? General authority is defined by 240 A.C. 7 of the Immigration Nationality Act. Basically says that if there's a change that's material that's happened within the last 90 days, you can submit that and ask the judge to reopen the case. All right? If there's a conviction that got overturned right after the case or something like that, we can move to reopen based on the general authority. You got to state new facts or evidence that were previously unavailable, that were not previously available, that's right. And there's a filing deadline of 90 days. We will talk about this term because it's going to come up in every one of these motions. This term is called equitable tolling. All right, attorneys know that term very well because we talk about it in law school. But the idea of equitable tolling is, that this 90 days can sometimes be extended a little bit. All right, sometimes can be extended a whole lot if you've got good arguments. All right, and we'll talk about that. The number limits apply, which means you can only file one of them. That's the general authority statute. Any question about that? Basically, if you've got a new change that's happened in your life, new facts, right? And if it's within 90 days or within some equitable time period, then you can ask the judge to reopen it.
Is it free to file that?
It's $110.
$110.
Yeah. All right. So the second one is to reopen an in absentia order. So if you missed your hearing and you were deported in your absence, or in absentia they call it, then you've got to show exceptional circumstances for your not appearing in court. All right. There's a case, if you have a traffic incident, your car breaks down on your way to the courthouse, all right? The BIA has decided that that is not exceptional circumstances, all right? Their position is your car breaks down on the way to the courthouse, you can get a taxi still to get to your hearing. Their position is they don't care, you should be in the hearing, all right? Now, medical emergency does. There are several cases where it's like, okay, somebody was in the hospital, they don't need to show up. But traffic incident, you have a flat tire on the road, does not cut it. If you're hurt, I would say you have a much higher chance of winning this type of motion to reopen. Does that make sense? You've got to show exceptional circumstances for not appearing in court. You've got a deadline now of 180 days. They give you more time, twice the time, to file. It's also subject to equitable tolling. If you've been in a coma for 180 days and now you just wake up and realize there was a deport order against you, they'll toll that time, all right? Also, if we can show there's no notice, and that's why you didn't show up, you were never notified at all, now there's no time limit. This is a huge thing to be aware of, all right? Our office has opened a case, one case to my memory, where there was a deport order from 10 years ago because the client didn't have notice, and we proved it. We actually got the EOIR FOIA and it showed the returned envelope of the hearing notices. And we're like, okay, that's pretty great, right? So number limits do apply. So you only have one. We good on this? All right, we're moving right along. All right, ineffective assistance of counsel. I don't like to file motions to reopen based on ineffective assistance of counsel because they aren't a good way to make friends with other attorneys, to put it quite frankly. You've got to file a bar grievance against the other attorney, all right? There are minimal exceptions to that, but basically the policy is if we're doing this, we've got to really say that the other attorney completely was so ineffective that it completely screwed up our client's case. And the BIA requires that we file a bar grievance and file disciplinary action against that attorney. All right. We've got to show that a prior attorney was ineffective and that their ineffectiveness caused prejudice to the case. In other words, just because the attorney didn't know what they were doing it's not enough to reopen the case. They have to have not known what they're doing, and their not knowing caused the client to not apply for cancellation of removal when they had a cancellation case. All right, something like that. You know, it's like they're not knowing, and they didn't seek a 212H waiver that they were clearly eligible for. They were not knowing, and they didn't file for asylum, even though they could have, right? Whatever, right? So we must first let the attorney know of our position, and we have to give that attorney an opportunity to respond. So that's a process that we need to go through. Type up a little declaration saying this is our position on why our client believes your service was ineffective. We don't know if it was or not, but this is what the client is telling us. Please respond within a reasonable time. Please respond within 10 days is what we typically ask. All right? Then we have to go through the motions of filing a bar grievance against that attorney. That must be filed within 90 days, but it is subject to equitable tolling. Equitable tolling on ineffective assistance cases often goes something like, hey, Your Honor, you got to reopen this because my previous attorney didn't explain like anything about what I was supposed to do. And they didn't explain that I needed to file an appeal. They didn't explain that I had an opportunity to file X, Y, and Z, and I only found out about it now when we got our FOIAs back or whatever. So please toll the filing deadline. All right. Number limits do apply. So you only have one. Make sense? Very good. Changed country conditions. All right. This is for asylum. If we're filing a motion based on this, the big thing is the deadline doesn't apply the way it normally does. It's not a 90-day thing anymore. You've got to file within a reasonable time, which is typically 180 days, of whatever that change is. And what do we have to show? We've got to show that there were changed country conditions in your home country that have materially worsened in your country, all right? What does materially worsened mean? It means it's got to be material to your claim for asylum, all right? You've got to show that you, in your situation, are now in more danger to go back to your country than you used to be. And if that's true, you can file this motion, all right? Number limits do apply, but the timing is more generous. We've just got to file shortly after, within a reasonable time of that change. Okay? All right, moving right along. VAWA, I'm not going to talk too much about this. Basically, if you're subject to battery or extreme cruelty by a U.S. citizen spouse or parent, or a LPR spouse or parent, you can reopen your case, and it extends the deadline for a year. Okay? The thinking there, policy-wise, is look, they send notices and stuff like that to addresses. They send notices to the same place where you might be living with an abusive spouse or parent, and that it might be based on that you didn't show up to court, right? That's kind of the policy thinking about this. And so if we're filing based on VAWA, then we have other arguments to reopen the case. Number limits still apply. All right, what's a joint filing? What's a joint motion to reopen? Who knows?
When the government agrees for the motion to be reopened.
Yeah, exactly. Everybody clear on that? How likely do we think that is right now? It used to happen quite a lot. And we can always ask. The way that I've had most success getting the government to reopen is actually completing the whole freaking thing first. Faxing over, really emailing a copy of, hey, this is our motion to reopen, would you be willing to join it? Right? And then sometimes I've seen that right now I feel like they're just saying no, yeah, good luck with that motion. Certainly back under Obama, people were more willing to negotiate on things. All right. The nice thing, though, is that if DHS is willing to join, then there's no more time limits. There's no more number limits. We can, if they were going to rejoin, then great. Okay. Anyway, there's a client that we have won a motion to reopen for based on DHS's joining. Makes it very easy. All right, and if you've got a strong case, then you can do that. The last one is sua sponte. All right, what does sua sponte mean? It's written right there, actually. It's of the court's own accord. That's the Latin phrase. And the court will never really do that. They will never really do that of their own accord completely. It's our job to put it in our motion, right? And the way it works, we'll talk about that in a minute, but the way it works is you argue your various arguments, and then typically your last argument is, and also please, of your own accord, please grant our motion to reopen in your discretion. Yeah, it's 100% based on the discretion of the court or of the BIA. The problem with a motion that's sua sponte is it's not appealable. All right, it is 100% discretionary, which means that if it's denied, you're stuck. And so the strategy is to never put your whole argument on a sua sponte motion. It's treacherous waters to put your whole argument on just that. All right? I want to talk really quick about equitable tolling. Equitable tolling can toll both things. It can toll, give you an extension of the date requirement, the filing deadline. It can also toll, I've seen it, the number requirement that says normally you can only file one motion to reopen. Well, if that first motion to reopen was done ineffectively, right, you can ask them to toll the number requirement as well. All right? So it can extend filing and number deadlines only if both are met. First, the person acted diligently in pursuing their rights. What does that mean? They can't have sat around for 10 years, right? If they knew that they had this motion to file, they can't have sat around forever. And they have to have been prevented by some sort of extraordinary circumstance. So we've got to explain the delay, right? This extraordinary circumstance can be the ineffective assistance of counsel. It can be the birth of a child. It can be hospitalization. It can be lots of different things. But we've got to go through the process of explaining the delay if we're not filing timely. All right? It's important to talk about stays of removal because, as I mentioned at the beginning, motions to reopen come at a dangerous time from the client's perspective. They can be picked up, they can be deported, all right? When you appeal a normal case, which is not a motion to reopen, when you appeal a case to the BIA, an appeal will automatically stay deportation, which means I'm not getting deported when an appeal is pending. But a motion to reopen does not. We clear on that? So, with two exceptions, one if it's based on VAWA, two if it's based on an in absentia order, all right? So we need a separate motion for a stay included with it. It's typically a one-pager, maybe 2 pages, separate motion, and you can also say motion for reopen and stay in like the cover caption or whatever. But we have to highlight the merits of the motion itself, likelihood of being approved, motion, and the harm that a deportation would happen to the family, to the client, things like that, all right? Which is, I don't know if it's presumed or not, but it's stronger in asylum cases, all right? Good. Any questions about that? All right, cool. So, putting it all together, all right? I've got 2 slides on this, kind of like how to put a motion to reopen together, all right? Step 1, figure out all the arguments of those 7 that we just went over. Figure out which of the 7 do we possibly have arguments for, all right? Include them all. We only have 1 motion, so we've got to include all arguments at that time. Step 2, we got to get declarations and evidence showing each type of eligibility for each of those types of motions, that we're eligible for equitable tolling if we're filing late, and that we're eligible for some form of immigration benefit once the case is reopened. All right? I put here, we've got to include any new application that we have. It's got to be in the motion itself. All right? Third, we have to write a brief, including all of those legal arguments. And then we attach the following, which goes to the next slide. And it's basically what all needs to go into it. A cover letter, your entry of appearance, the motion itself with all the legal arguments, the order of removal that we're seeking to reopen, evidence of the motion to reopen eligibility, including evidence of equitable tolling if needed, all applications that we would be requesting if the proceedings are reopened, a filing fee of $110 and a proof of service. That's it. Does this all make sense? All right. So thank you for listening, and I printed out some stuff.
Question.
Yes.
What's the difference between a motion to reopen and a motion to reconsider?
Good. Motions to reopen are based on facts that have changed. Motions to reconsider are based on changes in the law. Time deadlines are the same. It's 90 days to file a motion to reconsider. Equitable tolling can still apply, but but a motion to reconsider, it's a very, very similar concept. In fact, if you were to file a document that said the word motion to reopen on it, but you were just arguing changes in the law, they would treat it as a motion to reconsider instead. So it's like, you don't have to worry too much about it, but yes, it is a separate thing. Yeah. What I've just passed around here is something that I want to now add to our binder, like our sales team binders for consult purposes, just so that we can explain clearly, but it's also kind of the guide that I used as I was creating this and kind of thinking motions to reopen through. And so hopefully it's of some use. All right, yes?
What if we have a client that comes and he already filed 2 motions with 2 attorneys?
Then we've got to argue that both of those attorneys committed ineffective assistance of counsel on both of those motions if they're going to even try to do anything. But honestly, the real answer is you're probably screwed because there's a number limit that's hard to overcome. And, you know, I don't know, they lost their case in court, they lost a first motion to reopen, they lost a second motion to reopen, like the writing is on the wall that their case is going nowhere, right? And that doesn't mean that, hey, you know, that doesn't mean we're not willing to take a case like that. You know, it's just the client has to be informed from the outset that the chances of winning are very low, and we've got to do a lot of fancy footwork if we're gonna give it a shot.
So if they have a strong U visa later, they can't.
U visas can waive in the I-192. They can waive inadmissibility because of removal orders. So yeah.
So even though, like for her example, with the 2 motions that were denied, if they have a strong U visa, the third time will work to reopen maybe a case that.
We're not talking. So let's not confuse.
Oh, okay.
Let's not confuse it. If you have a deport order, which causes an inadmissibility, and you have criminal convictions, and you have fraud, and you have all kinds of problems, right? A U visa has the power to waive all of them. It's not easy, but it has the power to do that. The only thing that a U visa cannot, by law, waive is Nazi genocide. Everything else, the U visa, aggravated felonies, the U visa can, and we've seen it happen, the U visa can waive the worst of immigration and criminal violations if it is strong enough, if we explain it well enough, but it is not easy to do that. So a U visa is a completely different animal, and it can be the solution if a motion to reopen isn't. Make sense? VAWA can as well. A CAT claim can as well if you lost. Anyway, yeah, there's several things that can overpower a deport order. Thank you all so much. All right.